Are you trying to claim the bank account of a deceased loved one in the state of Missouri? If so, this video is for you. Hi, my name is Dan Schnurbush. I'm an estate planning and probate attorney out of St. Charles, Missouri, and we help families across the state of Missouri access their inheritance when somebody they love passes away. So today I'm going to talk to you about how to claim a bank account when somebody dies, all right? So there are a number of different ways to do that, and the most simple and easy way is to look at the title first. Who owns it? And if you have a situation where you have joint account holders, this is very common. Prior to people passing away, oftentimes they'll add their kids on the account, or they'll put some other joint owner on the account, or that's a married couple. When somebody passes away, if there are two people on a bank account in the state of Missouri, whoever the survivor is takes the entire account. And it's important to understand that this happens outside of probate. You don't have to go to court, it just happens automatically. Now, you can go to the bank and get the name of the deceased person taken off at any time. Now, from a planning perspective, it's important to understand what that means is that if your plan is to leave your bank account to, or put one of your children on as a joint account holder, and you hope that they will distribute it to your other children, don't be so confident in that. There are better ways to do that that are more secure and more safe. But if you're trying to claim it when they've died, that's the first thing to look at is, are there any other joint owners? Are you a joint owner on that account? If so, you should be able to claim it, okay? Second easy way to claim an asset when somebody dies is specifically a bank account, is if you are named as the transfer on death or pay on death beneficiary on that account. Missouri law allows account holders of bank accounts, savings and loan, brokerage, and other things like that to name a beneficiary to take that account automatically upon the death of all account holders. So let's say that your mom has a bank account and you are named as the pay on death beneficiary. You should be able to just go to the bank, let them know who you are, prove your identity, and they will switch the account over into your name. Now, if there are multiple co-owners, so like suppose there are two joint owners and you are the beneficiary, you won't have any rights to claim that account until all of the account holders are deceased. Does that make sense? So those are the easiest ways to claim an account when somebody dies, all right? Other very common way that you can see this happen is if the account is owned in a trust. If this happens and you are a trustee or a beneficiary, you should be able to contact the bank and get the account put into your name, as long as you're the trustee. So you have to be the one that has the authority to manage that account in order to distribute it to yourself, okay? Now, let's assume that the account that you're dealing with, what do we do if there is no joint owner? There is no beneficiary. It's not owned by a trust. It's just stuck in mom or dad's name or your cousin's name or your brother's name or whoever it is. It's just stuck in their name and it has no way to go automatically. So what does that mean in the state of Missouri? It means that piece of property, that bank account, is going to have to go through probate. Now, what kind of probate can make a great deal of difference in terms of how much work this is going to be and how expensive and how much time is going to be involved, okay? The simplest and easiest way to claim that account in most cases is using a small estate affidavit. But this only works if the account is under $40,000 and you are an heir of the estate, all right? Now, if you are fit into a couple of other specific buckets, you can, in those situations, claim it in a different way. So let's suppose you are the spouse or the married child or the minor child of the deceased person. In this case, you might be eligible to file what are called refusal of letters or a refusal of letters application, okay? And this is a different kind of short form probate in the state of Missouri. They can be even faster than a small estate affidavit. And the other thing is that it's more airtight. Nobody can ever make a claim against it, all right? So it depends on the county how much you can claim as a spouse or a minor child. And that's because under Missouri law, a spouse and minor children are entitled to certain exemptions, certain allowances out of the probate estate before anybody else can touch it. Creditors, heirs, anybody. There's a spouse and or minor children, they're entitled to certain exemptions. So that's where this refusal of letters concept comes from, is that we get this guaranteed amount going to the spouse and children. And so if it fits within that amount, they are allowed to claim the whole estate, no questions asked, right? And for example, in the city of St. Louis, that amount is $20,000. Anything under $20,000 is granted automatically for the spouse and minor children. You still have to go to probate and file through it. In most cases, you will need to file that application in probate court, but it should be able to be handled very quickly if you are the spouse or minor children of the deceased. In St. Louis County, you're looking at more like $24,000. They have a little bit higher threshold that they approve these. In some cases, they will get approved at higher amounts, but only under certain circumstances and only with additional proof of income and assets, okay? So check with your local county where you will be filing in order to determine what the limit is or the threshold is in that county for filing this kind of petition. They will be very helpful for that. Now, it's also important to note that a refusal of letters application is, in general, the only kind of probate application that is routinely allowed to be filed without hiring an attorney. In some counties, you can file a small estate affidavit as well without an attorney, but that's not going to be the case in places like St. Louis City, St. Louis County. I don't remember St. Charles County off the top of my head if they require an attorney or not. But you should check before you're hiring an attorney. You should check with your local probate office. And that's going to be the probate office where the deceased person either lived, or if they didn't live in Missouri, the place where the bank account is, the county in which the bank account sits. Okay? So suppose these don't apply. The bank account is larger than $40,000, and it's not just the bank account, it's everything in the estate. Everything the deceased person owned, including the bank account, has to be, for a small estate, under $40,000, and for refusal letters under $20,000 or $24,000. All right. And I almost forgot the last method of refusal letter application. You can file as a creditor of the estate. So, like, let's say you're a child and you paid for the funeral bill. It was $15,000. As long as the total value of the estate is less than $15,000, and there is no surviving spouse, is no minor child, in many cases you may be able to file as a creditor of the estate, but in most places only if it's for a funeral and burial cost bill. Okay. Other kinds of creditor claims will depend on the county in which you're filing and the judge's particular propensity in that venue. Okay. So let's say these don't apply. Let's say the amount of the estate is too large, and you still need to file for probate. In those kind of situations, one of two things happens, and it depends on how long it's been since the person passed away. If it's been less than a year, you're generally going to be looking at doing a full probate administration. Okay, that's generally about 10 months to a year in length. You're going to have to hire a lawyer. You're going to have to open an estate, publish in the newspaper. You're going to have to file an inventory and go through the whole process of a traditional formal probate. Okay. Now, Missouri, fortunately, is not as bad as some other states, but it is a much more significant undertaking. If it has been longer than 1 year since the date of death and the account value or the assets exceed $40,000, you can look at doing what's called a determination of heirship. This is a much shorter proceeding, usually anywhere from 8 to 10 weeks, in which we file a petition on your behalf. We get a court hearing date set. We go to court. We put on some evidence about the value of the assets and the heirs of the deceased. And then from that, we are able to get a court order that then you can take to the bank to get the account put into your name or distributed to the heirs of the estate. Okay. So these are some of the common ways to get access to a bank account, but it's best to try and avoid these problems altogether. If you want to look at doing some estate planning, or this is a thing that you want to make sure doesn't happen to your own kids, after claiming that account, make sure you set your own beneficiary on the new account. Make sure you talk to an attorney, consider doing a will and trust planning and getting it set up so that they don't have to go through this same process. Because the important thing to understand about probate is it's a totally optional procedure. It's just one of those things that is required when anything is stuck in somebody's name. So if you do a little extra work and make sure to set it up in proper form, either in trust or having beneficiary set, it's not going to have to go through probate at all. So just to briefly recap, whenever you're trying to claim a bank account, look at the joint owners. Are you a joint owner? Is somebody else a joint owner? If so, that joint owner takes the account. Are you a pay-on-death beneficiary if there is no joint owner? If so, you should be able to claim that account. If it's in a trust, you're going to need to talk to the trustee about getting a distribution of that account. If that's you, great. You can contact them, make sure you understand the terms of the trust and what is required of you by that document. You may need to talk to an attorney to figure out what you need to do there. If you do have to go to probate, if that bank account is stuck in their name, no joint, there's no beneficiary, there's no living trust, in that situation, we're going to have to look at probate. So in that, again, remember it based on the value. So if it's small, you might be able to file as a creditor. If you're a spouse or a minor child or the parent of a minor child, you might be able to file a refusal letters application. If you don't fit any of those buckets, but it's under 40,000, you might be able to file a small estate. It's over 40,000, we're going to be looking at a more formal probate unless it's been longer than a year since death. Okay, so that's kind of how to claim a bank account in the state of Missouri. If you enjoyed this content and you have any other questions about Missouri probate law and how it applies to your situation, keep checking out some of our other videos. Give us a call, and we'd be happy to go through your particular situation to see how we might be able to help you. In the meantime, like and subscribe for the algorithm, and we'll talk to you next time. Take care.